Welcome to this morning's In-House in Focus webinar. For those of you who don't know me, I'm Jane Hussey. I'm a commercial contract specialist, and I also lead the Mills Reeve In-House in Focus programme. Feedback from sessions we've run over the last 6-8 months has shown that data protection is a topic that our in-house community is very keen to hear about. So I'm delighted that I have two of our specialists, Paul Knight and Richard Sykes, here to give you a data protection update. As with all of our sessions, Paul and Richard are going to aim to keep this session to 30 minutes of speaking and then to allow 10 to 15 minutes of questions. And on the subject of questions, you will see a Q&A box at the bottom of the screen. Please do pop any questions you've got in there and we will try and deal with as many as possible at the end. I should say that the questions appear only to us panellists, myself, Richard and Paul, and therefore please don't be shy as to any questions that you want to ask. As always, the session is going to be recorded and slides and a recording of the session will be circulated in a few days' time, and please do feel free to circulate the slides and the presentation to any of your colleagues who haven't been able to make it. As we close today's session, a feedback screen will pop up, and we'd be really grateful if you could just take a moment to give us feedback on today's session, and in particular steer us as to future topics you would like to hear about. So without wasting any more time, I'm now going to hand over to the lovely Paul Knight to kick off the session.
Thanks, Jane, and hello everyone. So as advertised today, we're going to cover the latest position on cross-border transfers of personal data, including updates on the EU adequacy decision for the UK and standard contractual clauses. Data sharing within the UK and the new data sharing code of practice that's come out, recent ICO decisions and penalties for data breaches, and trends in claims by individuals under the data protection legislation. So I'll do the first two of those bullets, and then Richard will do the second two. Now, given the nature of this session and the desire to keep things briefish, Richard and I are going to assume some knowledge of the data protection legislation, which includes the good old EU GDPR that applies essentially to the processing of personal data by an organisation established in the EU, or where the processing activities are related to offering goods or services to individuals in the EU or monitoring their behaviour. But the UK obviously isn't within the EU, so these days we're more usually considering the UK Data Protection Act 2018 and the UK GDPR, which came into effect on the 1st of January 2021. I want to start with cross-border transfers of personal data because I feel it's the area of most excitement in the context of data protection at the moment. There is a general principle under both the EU GDPR and the UK GDPR that personal data cannot be transferred to a third country or to an international organisation unless certain conditions are complied with. And as an aside, you probably know this, but international organisations are organisations governed by public international law, or a body set up by or on the basis of an agreement between two or more countries. So Interpol and the United Nations are a couple of examples. Now, because the definition of a third country differs between the two GDPRs, this general principle means that under the EU GDPR, you can't transfer personal data outside the European Economic Area without complying with certain conditions, whereas under the UK GDPR, you can't transfer personal data outside the UK without complying with certain conditions. So on the face of it, Brexit's created this hurdle to overcome when it comes to flows of personal data between the UK and the EEA, which means if you use a technology system that involves personal data held by your organisation in the UK sitting on a server somewhere in the EU, or if you work with other organisations based in the EU and may need to share personal data with them, then we're needing to look at those conditions that have to be complied with. Both GDPRs allow personal data to be transferred without any additional safeguards needing to be put in place to countries in respect of which an adequacy decision has been made. In the case of the EU GDPR, that's a decision by the European Commission. And in the case of the UK GDPR, it's a decision by the Secretary of State for Digital, Culture, Media and Sport. There are a number of countries that the UK has already decided are adequate for these purposes, and the relevant legislation confirming this is Part 3 of the new Schedule 21 of the Data Protection Act 2018. This schedule was added by what gets referred to as the DP Brexit Regulations. You can see from the slide that the UK adequacy regulations cover transfers to any EEA state, to Gibraltar, and to those countries in respect of which an adequacy decision has been made by the European Commission before IP completion day. This isn't an exhaustive list, by the way. There are some other permitted transfers, but these are the ones I anticipate being most relevant. But the big question from our perspective at the moment is whether transfers from the EU to the UK are going to be covered by an adequacy decision. The EU-UK Trade and Cooperation Agreement says that for a specified period, which was initially 4 months, but automatically extended by a further 2, the UK will not be considered as a third country for the purposes of the EU GDPR. So personal data has been able to flow freely from the EU to the UK during this period. This bridge, as it's known, finishes at the end of this month. Back in February, that didn't feel like a problem after the European Commission published its draft adequacy decision in favour of the UK. But the European Data Protection Board subsequently raised some concerns about this, and towards the end of May, MEPs passed a resolution asking the Commission to modify its draft decision. The objections relate primarily to the exemptions in UK legislation for data processing in the fields of national security and immigration, and concerns about onward data transfers. In terms of process, the European Commission is obliged to take the opinion of the European Data Protection Board into account, and then will request the green light from the member states' representatives for adoption of the final adequacy decision for the UK. However, given the MEP's vote, it isn't guaranteed that this green light will be given as things stand. We're now running out of time before the Trade and Cooperation Agreement's bridge collapses. If there's no adequacy decision in favour of the UK before the end of June and no extension of the bridge, then one of a list of appropriate safeguards from the EU GDPR will need to be put in place to allow for the transfer of personal data from the EU to the UK after June. The most commonly relied upon appropriate safeguard is the use of approved standard data protection clauses. I'll come back to standard contractual clauses for transfers from the EU, but first want to confirm the position for transfers of personal data from the UK to somewhere that is not covered by an adequacy decision. If before Brexit, you had agreed the EU standard contractual clauses to cover a transfer from the UK, which at the time was part of the EU, then the position currently is that you can continue to rely on those standard contractual clauses as an appropriate safeguard for the restricted transfers from the UK described in the relevant appendix to those clauses. The slight caveat to that is that in light of the Schrems II judgment, which invalidated the EU-US Privacy Shield, amongst other things, you should be reviewing whether the standard contractual clauses provide protection which is essentially equivalent to the protections in the UK data protection regime. The ICO is intending to issue further guidance on these so-called transfer impact assessments, but there is a bit more of a steer from the EU on this, so I'll touch on that in a moment. Now, if you're considering a new arrangement where personal data will be transferred from a UK-based controller to a different organisation based somewhere not covered by an adequacy decision, then again, you should carry out a transfer impact assessment, but subject to that, you can use the old EC-approved standard contractual clauses that applied before the end of the Brexit transition period, and you can make changes to those clauses so they make sense in a UK context, provided you do not change the legal meaning of the clauses. This is confirmed in the new Schedule 21 to the Data Protection Act, and it means you are allowed to change references to the old EU data protection legislation to refer instead to the UK GDPR, and change references to the EU or member states to refer instead to the UK, and you will still have an appropriate safeguard for the cross-border transfer of personal data so far as the UK GDPR is concerned. Indeed, the ICO has published versions of the approved standard contractual clauses in which it has made these changes, and those can be accessed from its website, which is helpful. At the Data Protection Practitioners Conference last month, the ICO's Deputy Commissioner confirmed the ICO is working on bespoke UK standard clauses for international transfers of personal data, and that it intends to go out for consultation on those this summer, which is a relief to hear, because there are scenarios where a UK-based processor doing things with personal data on behalf of another entity rather than for its own purposes and means may need to transfer personal data to somewhere not covered by an adequacy decision, and we don't currently have standard contractual clauses to cover that, whereas the EU does now. So on Friday last week, the European Commission adopted new standard contractual clauses for the transfer of personal data to third countries. The implementing decision will be effective on the 20th day following its publication in the official journal of the European Union, which is due to happen imminently if it hasn't already happened whilst I've been talking. The new clauses use a modular approach to cover 4 different scenarios, and you can't modify them except to select the appropriate module or to add or update information in the appendix, which is the same approach that we've had previously. Now, these 4 different scenarios covered by the different modules are controller to controller transfers, controller to processor transfers, processor to processor transfers, and processor to controller transfers. The European Commission is presenting these new clauses as the answer for cross-border transfers of personal data. So they've actually said that these new standard contractual clauses reflect new requirements under the GDPR and address the realities faced by modern business. Thanks to their standardization and pre-approval, the SCCs provide companies with an easy to implement template. Companies know that when they use this template, they meet data protection requirements. Now, going into the detail of these new clauses would be a webinar or even a workshop in itself, but for transfer impact assessments, it is worth noting that these clauses require the parties to declare that they've taken due account of the specific circumstances of the personal data transfer, including the length of the processing chain and the number of actors involved and the transmission channels used, of intended onward transfers, of the types of recipient and the purpose of processing and the categories and format of the transferred personal data, as well as the economic sector in which the transfer occurs, the storage location of the data transferred, the laws and practices of the third country of destination, including those requiring the disclosure of data to public authorities or authorizing access by such authorities, relevant in light of the specific circumstances of the transfer and the applicable limitations and safeguards, and any relevant contractual, technical or organizational safeguards put in place to supplement the clauses. The assessment of these factors has to be documented and made available to the competent supervisory authority on request. So in the absence of anything further from the ICO, that appears to be a pretty good summary of what we must be considering as transfer impact assessment, even for the purposes of UK GDPR compliance. You can find that information listed in clause 14 of the new EU standard contractual clauses for transfers to third countries. For those that are transferring personal data from the EU to somewhere that hasn't received an EU adequacy decision and are relying on the old standard contractual clauses to do so, there is a transitional period of 18 months. After that time, the new standard contractual clauses will need to be agreed to in place of the old ones. Now, just finishing up on cross-border transfers, you'll probably have gathered there are some slightly tricky scenarios at the moment. The new EU standard contractual clauses present a solution for lawful transfers of personal data from the EU to the UK if no adequacy decision is confirmed by the European Commission before the end of the month. So you may be wondering at what point you need to start getting those in place. Well, it feels like there is the option to be led by the EU-based entity in that respect, because it is the entity subject to the EU GDPR that's bearing the risk. Remember, the flow of personal data from the UK to any EEA state is permitted already without appropriate safeguards having to be put in place. And a good thing about using standard contractual clauses is that they cannot be negotiated. So finalising and executing them should be a comparatively quick and easy task. And personally, I haven't actually given up hope of an adequacy decision in favour of the UK being confirmed. If that happens, then the EU-UK transfer of personal data will no longer be tricky. In relation to transfers to the US, you need to carry out the transfer impact assessment to determine whether standard contractual clauses provide enough protection. And the European Commission has taken the Schrems II judgment into account in preparing the new EU standard contractual clauses, which include stronger commitments on the data importer if attempts by public authorities in the third country, such as the US, if there are attempts by the public authority to access EU originating personal data. Consequently, if having done your transfer impact assessment, it is felt that the current UK standard contractual clauses don't provide enough protection, there may be scope for them to be supplemented with relevant provisions from the new EU standard contractual clauses to minimise your risk as a data exporter. I am aware, by the way, that some US organisations still refer to the EU-US Privacy Shield in their standard terms as the basis on which data can be transferred from the EU or UK to the US. That definitely doesn't work. And questioning that and highlighting the concern about how seriously that US organisation takes data protection, given that the EU-US Privacy Shield ceased to exist in July 2020, has generally prompted a positive discussion about alternative safeguards that can be put in place, in my experience. Indeed, some smaller organisations based outside the UK and EEA have welcomed a solution being provided to them by our clients, such as the UK standard contractual clauses, and readily agreed to them in place of their out-of-date standard terms. And in relation to the third tricky scenario, relating to UK processors, the sooner the ICO plugs the gap with new UK bespoke standard contractual clauses, the better. In the meantime, a pragmatic measure could be to consider amending the UK controller to controller clauses, which, though technically incorrect, would demonstrate that contractual protections are in place. And I think there should be value in doing this, as the ICO stated it will apply a risk-based and proportionate approach to its oversight of international transfers. And this approach essentially means the controller based in a third country is taking on the same obligations that it would do so if the UK-based processor was a UK-based controller of the personal data, when using the controller to controller clauses could provide the appropriate safeguard. Now, before handing over to Richard, I must just flag the latest on data sharing within the UK, where none of this cross-border stuff applies. There have been announcements from the Department of Digital Culture, Media and Sport about the importance of data sharing to position the UK as a global champion of data. And the ICO's new data sharing code of practice has now been laid before Parliament and will come into force before the end of this month. The code of practice is a statutory code, and the Information Commissioner must take the code into account when considering whether you have complied with your data protection obligations when sharing data, so it is worth following. To summarise a couple of key messages, data sharing on a controller to controller basis is encouraged, but having a data sharing agreement in place, while not made mandatory by the code of practice, is identified as something that can form a major part of compliance with the accountability principle under the UK GDPR. And where a data sharing agreement is going to be used, the code of practice lists out a range of questions that should be addressed in the agreement. Those are outlined on the slide, although there is more detail in the code itself. Now, the level of detail that a data sharing agreement goes into should be proportionate to the nature and quantity of the personal data being shared. Where relatively little personal data will be shared and the personal data shared will not be of a sensitive nature, comparatively short form clauses seem appropriate. If a large amount of personal data will be shared and/or the personal data shared will be of a sensitive nature, then more extensive provisions are appropriate, covering in more detail, for example, the technical and organizational measures that will be put in place to keep the data secure. As a practical point, having compared some short form data sharing clauses to what the ICO expects to see in a data sharing agreement, I think the things that risk being missed out in short form clauses include contact details for the individual with responsibility for the data sharing within each organisation, which might be the data protection officer, an explanation of the lawful basis for sharing data, and a timescale for assessing the ongoing effectiveness of the data sharing initiative and the agreement that governs it. There are simple ways to cover those points, so it's worth looking out for whether they've been omitted, for example, in the practical law company precedent, and adding them in if they're not already there. Right, looking at time, I'm proposing to hand over now to Richard, then pick up questions after he's talked about what happens if things go wrong. Richard.
Thanks, Paul. As promised, I'm going to cant a few recent ICO decisions and penalties, including a couple dealing with data breaches, and then consider claims by individuals that we've been seeing coming in connection with the data protection legislation. Viewing the ICO website on action we've taken reveals that a lot of its recent enforcement activity appears to have been in connection with direct marketing, and I thought it would be useful to have a quick look at two of those decisions in order to compare them. Now, both are actually under the old Data Protection Act, but the underlying points do remain very much the same. The first one involves American Express, a household name and provider of a purchasing card sort of system. The ICO imposed a monetary penalty of £90,000 under Section 55 of the 1998 Data Protection Act in relation to a serious contravention of the Privacy and Electronic Communications Regulations. This arose because 3 of Amex's customers complained to the ICO that they were receiving marketing emails from Amex after they had opted out. Amex's explanation to the customers had been that the emails were what they called servicing emails rather than what they called marketing emails, and that they felt that cardholders would be at a disadvantage if they didn't receive these servicing emails and heard news of the campaigns and promotional periods that were contained within the emails. The ICO initiates an investigation, sends a letter to Amex asking a number of questions and asking it to provide certain evidence. Amex's response to that was to initiate an independent investigation into its emails to cardholders and the circumstances in which it had undertaken those, particularly in relation to the opt-out, opt-in boxes that they had on various websites and paper applications. And it found that a number of emails had been sent to customers who had not ticked boxes asking to be sent information about promotions and indeed how to get the most out of their Amex card. That number of emails was 4,098,841 in the year from June 2018 to May 2019. The ICO took this into account and treated the breach of the privacy and electronic, I beg your pardon, the PECAs as being serious. But since Amex had not set out deliberately to breach the PECAs, it had been negligent in doing that, in that it knew or ought to have known that there was a risk that it was breaching PECA and that it failed to take reasonable steps to prevent that breach. There were a number of mitigating factors that the ICO took into account, and in particular two, that when it contacted Amex and to say that it had identified this problem and had these complaints, Amex stopped all marketing and servicing emails to those who had opted out and instigated the independent investigation. Amex also voluntarily reported the outcome of the investigation to the ICO and notified the ICO that it had made several changes to its systems to ensure its ongoing compliance with PECA. So £90,000 for 4 million odd emails. Our second case involves the Stoke-based Stoke-on-Trent based Colour Car Sales Limited, which found itself being imposed with a £170,000 monetary penalty, also under Section 55 of the Data Protection Act. CCS is a credit intermediary providing finance for used cars. And in just shy of a year, the ICO received 34 complaints directly and 144 through a text messaging service that any of us can use. If you receive an unsolicited marketing text message, you can just simply forward it to 7726, which on your alphanumeric keyboard spells out spam, and it'll be logged by that service. All of these complaints were about unsoliciting marketing by text. By contrast to the approach taken by Amex, when the ICO got in touch with CCS about these emails, CCS didn't respond because the address that it had at Companies House was incorrect. The ICO sent an email to it containing the letter using the email address logged at Companies House. That too was incorrect. So eventually the commissioner phoned up the individual who provided the right address. CCS provided an initial response asserting that only people who had started a finance application on its website were ever sent the text messages. And of 3,001,385 text messages sent over the last year, only 27 individuals have lodged a complaint with you. All further inquiries by the ICO in connection with this matter went unreplied to, received no response. And because of the lack of response, the ICO was only able to hold that 274 text messages were sent in breach of PECA. But it believed it was likely that all 3 million odd were similarly sent without consent. The ICO, as it did with Amex, considered that the breach was serious. But unlike Amex, it concluded that CCL did set out deliberately to breach PECA in that the actions it had undertaken were deliberate. The ICO also identified a number of aggravating features. First, the CCS had acted without any regard for PECA, simply in an effort to generate income and profit. Secondly, that CCS was a member of the Financial Conduct Authority. And so not only was the ICO's guidance on PECA and similar marketing communications available to it, but also guidance from the FCA would have been available. simply put, CCS also failed to cooperate with the investigation. And there were two further factors that clearly irritated the ICO and indicated that CCS was being evasive, in that its registration with the ICO was itself out of date, and as I mentioned, the details at Companies House were out of date. So alongside, what do we draw from these two cases? Well, alongside concluding that it's worth being clear about what is marketing communication and what is not a marketing communication, and also getting one's consent for obtaining and recording that consent properly sorted out, we can conclude that it is well worth cooperating with the ICO if and when it gets in touch with an investigation. So what sort of penalties have we been seen imposed for data breaches? Well, one of the largest, and the one that perhaps give us the clearest indication as to how the approach under the GDPR is going to be taken, is that which was imposed on British Airways. Now, in 2018, BA suffered a cyber hack in which the hacker obtained access to a lot of customers' names, addresses, and payment card details. In July 2019, the ICO sent British Airways a notice of intent letter, which intention to prosecute, which indicated where the ICO was thinking the level of monetary penalty might sit, which, because BA was a public company, BA had to report to the market. And that note of intent indicated a penalty of £183.9 million for BA's breaches of its security obligations. Among the things that the ICO had taken particularly into account in setting that level of monetary penalty was BA's global turnover. BA itself responded to the ICO's allegations and questions, provided a range of evidence, argument, and information, and consequently the ICO ultimately assessed the fine at £20 million, noting that BA didn't gain financially from the breach of the Data Protection Act that was involved. The infringement was neither deliberate nor intentional. The BA had no relevant previous infringements or failures to comply with past notices. BA had fully cooperated with the ICO's investigation, that no special category personal data was involved in the breach, and BA had acted promptly when notifying the ICO, all of which are good data protection compliant things. Again, we see here the value of cooperation revealed. The monetary penalty was still significant, but had been reduced by about 89% from where it had been initially indicated. But not all of that reduction was due to cooperation. BA argued, seemingly with some success, that the policy the ICO had sought to adopt of basing the penalty mainly on BA's global turnover was unlawful. Now, while the ICO say that it is not unlawful, it did say that turnover had become a factor rather than a driver of the amount of the fine. A second issue around penalties for data breaches that I wanted to mention was in connection with individuals. Employees who misbehave with their employees' personal data can also find themselves into trouble. One day, the year before last, I think it was, a car fleet management company found that one of its drivers was getting nuisance calls about an accident he'd been involved in. That car fleet management company reported it to the RAC because the RAC had recovered the vehicle, and the suspicion of the fleet management company was that there'd been a data leak from the RAC. The RAC undertook a data leak scan of its mailboxes and found that one of its employees, a lady called Kim Doyle, had been compiling lists of of car accident data. These lists weren't authorized. It was no part of her job to do this. And it found that she then sold those lists onto a chap called William Shaw, who ran a claims handling company. And it was that claims handling company that was getting in touch in a nuisance sort of way with the guy from the car fleet management company. The RAC reported the data breach to the ICO, who decided to pursue a prosecution of the individuals. Both Doyle and Shaw entered guilty pleas to the offences of conspiracy to secure unauthorised access to computer data. That's a very exciting sounding offence. And also Kim Doyle pleaded guilty to an offence of selling unlawfully obtained personal data. As you can see from the slide, Miss Doyle received a sentence of 8 months imprisonment, which was suspended for 2 years. So if she doesn't misbehave in that period of time, she won't be going to prison, but also has to undertake 100 hours of unpaid work as a fairly significant contribution to the cost of the prosecution. And under the Proceeds of Crime Act, the £25,000 that it was assessed that she profited from has been claimed back from her. This shows that it's not just the companies, the data controllers that can get into difficulties as a result of data breaches. It can happen that rogue employees find themselves in problems. I'm not going to spend long on this data breach data slide, but while pulling together the material for the talk, I came across the data that the ICO publishes on data breaches that it's had reported to it, and it is always vaguely interesting reading that. The first quarter of this year, you can see that there were 2,425 data breaches reported to it, of which the majority weren't cyber incidents at all. And in fact, the most common one, and all the percentages, I should say, for the maths geeks amongst us here, all the percentages are of that 2,425 figure. But the largest single item was the good old-fashioned emailing the wrong person type things. But I am very amused that there is still a good number of things being posted or faxed to the wrong recipient. And that notwithstanding that most of us have been working at home rather than the office, and thus perhaps not with access to a fax machine. But there we go. So yes, if ever you're bored, then do have a look at those data. It's entertaining, if nothing else. Moving on, we're seeing something of a spike in claims, or at least letters of claims, being sent by individuals who are alleging that their personal data rights have been infringed and they claim damages. Now, there are a few firms, and there are one or two in particular, from whom we seem to be getting, our clients seem to be getting letters more often than other firms that are sending pretty much standard form letters. This slide is showing pretty much the standard letter that one firm is sending out. Now, I'm calling it pretty much standard because broadly the same letter has been sent to 2 different university clients on behalf of 4 different individuals following what's called the Blackboard data breach. Now, Blackboard is a software provider that many universities use to help manage its relationships with their alumni. And we've also seen pretty much exactly the same letter sent following breaches by health sector clients. You can see that the claim identifies, the claims identified in the letter are not all that surprising, with the possible exception, I think, of the Article 8 element of it. Article 8 being the right for respect and family and private life. And I'd be inclined to think that's a little bit of kitchen sink type pleading to throw that one in as well. But the Misuse of Private Information, Breach of Data Protection Act, and indeed the breach of privacy element of it are all what you might expect to see. I have to say that the assertion that the matter is suitable for the multi-track and the High Court is somewhat frustrating, particularly since the basis upon which that's done in this standard letter is the complexity of the claim. And these letters never indicate what they believe their client is likely to recover, which of course makes it more difficult to put forward some form of settlement proposal, which is often what a client will want to do at this point. How might one, CFA and ATE CFA is a conditional fee agreement, which is essentially no win, no fee type arrangements, and ATE is after the event insurance, which the claimant can take out in order to protect him or herself from costs orders later. And it's in responding to these claims that I thought you might want to have a bit of a think around. If you get a letter of this kind, I think the last of those bullet points is probably the first thing to do, which is to check whether it's an insured risk for you, because if it is, bring in the insurer. And I say that because the presence of the conditional fee arrangement can very quickly make settling the claim very expensive. And to that end, if there has been a data breach, it is worth admitting that and making the argument not about whether or not the breach occurred and not about whether or not you might be liable as a matter of law, but actually about how much the compensation for that breach might be. And because the presence of the conditional fee agreement can quickly make the claim expensive to settle, as the claimant's costs will exceed the value of the claim. And you may find yourself, as one of our clients is now, arguing over costs and spending almost more on that than the value of the claim itself. There are a number of ways of responding to it, but in essence, you'll be looking to address whether or not there was a breach of the individual's data rights, and if so, possibly conceding that and focusing on the damages that flow. Rather frustratingly, we still do not have case law telling us about the value of a typical data breach, as it were. So we still have claimants thinking that they might be able to retire on the basis of a claim that an email was sent astray. And with that, I can see Jane getting increasingly twitchy and anxious over time. So I shall move on.
Thank you, Richard and Paul. That was fabulous. So we have had a lot of questions. The majority of them are around issues on international data transfer. One that isn't, though, one of the first questions that came in, I think this comes down to definition of personal data. Do photographs taken by photography students used in a public exhibition constitute, fall within the scope of GDPR and so on? So I don't know which one of you would like to answer that.
Yeah, I'll take that one, Jane. So the answer is it depends. And there's some good ICO, well, there's some helpful ICO guidance on photographs and images of people in its guidance on what is personal data. But essentially, if you are if you're using a photograph and you can identify someone from it, that their image is clear, then you are not automatically processing personal data for the purposes of the data protection legislation. So if you're not processing the image to learn something about them, then it isn't subject to the data protection legislation. Whereas if you are using the photograph to for making decisions about someone or for learning something about them, then it is caught by the data protection legislation. There's an example that the ISO gives of a photograph taken by a journalist of people on the beach, just to illustrate that it's a nice sunny day in Britain, and you can identify, people are clear in the picture. That is not data processing for the purposes of personal data processing for the purposes of data protection legislation, so far as the ICO is concerned.
Thanks, Paul. And I've got to comment that if I was at home, you might hear a dog barking. Because I'm in the office, what you can hear is building work on the roof. So I'm sorry if there's any interference, folks. Next question, and I think this is a really interesting question. Somebody has commented that their business has branches in countries in sub-Saharan Africa, and that they have a lot of wranglings with colleagues who are saying, well, no, that's part of our organisation, so that's not outside of the UK. We don't have any problems in transferring personal data. So I've got a feeling you're going to disagree with that, the position this person's colleagues are taking, Paul.
So the ICO has actually been very clear in its position on this, which is that if personal data is going to an office or a branch of the same legal entity, but that office or branch is outside the UK, then that is not a restricted transfer under the UK GDPR. So you don't have to worry about all that cross-border stuff in that context. If, though, you've got a group of companies and a separate company is incorporated in Uganda, for example, then the transfer of personal data amongst the group would, in that situation, be treated as a restricted transfer.
Oh, that's interesting. So the distinction, Paul, is actually the nature of the entity as to whether it is a branch or a separate legal entity.
Yeah, I have to say, looking at the data protection legislation itself, it isn't immediately obvious that you would reach that conclusion, but that is the ICO stance.
Very helpful.
Paul, would it be right to think that one of the key things to make sure happens there is that literally the stuff stays in the branch, the personal data stays in the branch, and doesn't leave the branch? You have a sort of a pocket of that company that is literally the building or the do you see what I'm driving at?
Yes, I think you run into restricted transfer issues if the personal data then goes outside of that office or branch that is outside the UK.
Another question around the status of a third country in the context of Northern Ireland, Paul, and in the context of the Northern Ireland Protocol. So what's the position there?
Yeah, so for the purposes of the data protection legislation, Northern Ireland is outside the EEA, and so it's treated in the same way as England, Wales, and Scotland for these purposes.
Transferring personal data to the US, and should the standard contractual clauses on the ICO website be used following Schrems?
So standard contractual clauses aren't the only appropriate safeguard that can be put in place to legitimise transfer across border where there's no adequacy decision. So it wouldn't be correct of me to say that you must always use standard contractual clauses for transfers to the US. It's most likely that is going to be the mechanism for lawfully transferring personal data to the US. You do need to do these transfer impact assessments to judge whether what is being transferred essentially is going to be appropriately protected. I know there's another question, I think, about sort of comparing the concerns about UK position with the US situation. And it is not the case that that transfers of personal data to the US from the EU are prohibited completely because of the issue of access by US authorities to data. You need to be considering how likely that is that the US authority, or indeed in our situation, the UK authority, is to want to access that personal data. So you can take into account practical experience of public authorities accessing the data to judge whether using standard contractual clauses as your mechanism for the transfer of personal data does provide basically sufficient protection.
Okay. And sticking with Schrems, actually, another sort of question stroke observation's been raised as to if there isn't an adequacy decision for sending data from the EU to the UK, doesn't that itself raise Schrems problems?
It's that point really, Jane,
yeah,
of
yeah.
Consider what is being processed, what is going to be transferred on a case-by-case basis. The UK position, as far as the EU is concerned, could be similar to the US position, but in both circumstances, that might mean the answer is put in place these new EU standard contractual clauses, which have been drafted to address the Schrems 2 problems.
Okay, very conscious of time. A really interesting question here as to what approach would we recommend where we have a controller using a data processor in a jurisdiction where there is an adequacy decision, but that processor then uses a sub-processor in a country where there isn't an adequacy decision. What sort of approach would we recommend? Is it slightly modified versions of the old EU standard contractual clauses or something else? Do you have thoughts on that?
Yeah, so I think the initial point there is that the onward transfer by the processor needs to be compliant with its local laws, which will have been deemed adequate to protect personal data. So that processor should then be doing things that mean its transfer to the sub-processor outside the relevant jurisdiction are done compliantly with local laws. The expectation would be, if that is done, then that works from a data protection, from an UK or even a EU data protection perspective, given the adequacy decision made on the adequacy of the local laws. Okay.
Another question, does consent override requirements of adequacy decisions and standard contractual clauses for cross-border transfers?
Yeah, so there are derogations where it is permissible to transfer personal data internationally, even though there's no adequacy decision and none of the appropriate safeguards listed in the legislation have been put in place. and consent is one of those that you need to make sure it is informed consent. People genuinely know what they are consenting to and sort of what the risks are.
Yeah, absolutely. And Richard, I think one for you, are we seeing the misuse of DSARs by disgruntled employees?
Short answer to that is yes. That subject access requests are being used as a tool in connection with litigation or any grievance. We have had a decision from the High Court a little bit earlier that may put a different tone on the way in which the ICO approaches subject access requests, in that, if a request is clearly without a good purpose, is more being used more as a tool to try and obtain documents rather than personal data, and is mischievous or in some other way being misused, then you would not be penalised for not responding to it. The particular circumstances of that one, the cases Leeds and Lloyds Bank from last year, the bank's refusal was okay because there were numerous and repeated requests. The purpose was to get documents, not personal data. The collateral purpose was actually to try to prevent the bank from bringing claims for possession of the guy's property that it was entitled to do. And as a matter of fact, the data being sought at the point at which the court was considering the order would have made no difference, because the county court had already considered the claim. So there are a whole string of things in that particular case that meant that you didn't have to respond to the subject access request. But there's also guidance that the Information Commissioner has issued on Article 12(5), the manifestly unfounded and manifestly excessive things that mean that you don't have to respond to a subject access request.
Okay, I'm very conscious of time. We do have a few questions we haven't been able to answer. What we will do is draw this meeting to a close, and we will then take a look at those questions that we haven't been able to answer, and to the extent we've got your contact details, we will reply to those. I know a couple of people have put theirs in as anonymous, so if you then send myself, Richard or Paul a mail separately, we can pick up on your question. Kate is going to now put up a feedback screen, so if you wouldn't mind completing that, it will only take a moment, but like I say, it does inform our programme going forward, and indeed this session itself was born out of the feedback that we've received. So it just remains for me to thank again Richard and Paul for their contribution. It's absolutely fascinating and very informative. To thank you all for participating, and to thank you for your all of the questions and your engagement in this. So thank you very much and have a good day.